All right, so lastly, the power and pitfalls of redirect. So this is what I want to think about. The power. You have to understand that the jury, at this point, you've asked questions, they've asked questions, the jury thinks it's over. The jury thinks this witness is going on and we're moving on to the next one. So you can see this eye roll and this gasp in the jury when you stand up again, right? And the judge goes, any redirect? You see the jurors look at each other and go, what on God's name? Are we doing this again? Right? That is their precise reaction. So you have to make sure that you manage that and understand that's coming. Right? I like to say, jury thinks it's coming. I like to say something like, Your Honor, briefly. I have brief questions. You know, I'm a lawyer. Briefly means a lot of different things. Maybe it's briefly for the next hour. Right? But I'm going to say something that sort of helps them out without them standing back up. I have a few questions in redirect in light of what just happened. Right? It's not my fault that I'm asking questions. Again, it's his or hers, the other side's. So I might want to say something to help them out that this is going to be short or it's only in reaction to what just happened. But you have to understand that they think it's over. I want to combat the ideas and the points of cross-examination. I'm not worried about the individual questions, right? I am worried about the overarching points. So in a large case I had with 5 defendants, one of the things that happened every cross-examination for every one of those 5 defendants that went on. So I was doing a redirect not of 1 cross-examination, but of 5 that went on for a long time. The overarching theme of all of them is, hasn't the government just picked these 5 out of thin air? Isn't the government just unfairly looking at these 5 when there were so many other people that were involved and so many people that did things? So how do I combat and redirect that idea, that overarching theme, not any one question in the days of cross-examination? So I thought about it, I reacted, I was listening, and my first question, as I stood up, I think sealed my entire redirect. I said to the witness, and this is not something I prepared, this is not something I could have possibly gone over with this witness, but I went, who in this organization, of all the people you've talked about over the last couple of days, who were the 5 that had the most to do with it? Who were the 5 that were at the center of all the decisions? Who were the 5 most important? So I asked a series of questions that was like, who are your top 5? And her first answer was the best, because she literally looked at me. That's funny, we didn't prepare that. You were pretty good at preparing me. You never prepared me for the top 5 list. And she looked at me and went, well, this person, and then she realized that she was naming the 5 people in the room. And then it turned into that person, and that person. And it became really powerful to combat the idea and redirect that you might have went on for days about all the other people involved, but the 5 that are sitting in this room are the ones that were the most involved, or the ones that made the decision. So I combated the idea in cross-examination, not the individual question. You really have to pay attention. The people that go on and work on their next witness or work on their closing argument, you have to pay attention to what's going on in cross. And you not only have to pay attention to what's going on with your witness and the facial expressions and the body language, you have to pay attention to that jury, the ones receiving the information. You will see, right, and I know this as a professor, you will see confusion in their eyes, right? If we are experts at anything, it's that moment when people look at you and go, I have no idea what he's talking about anymore, right? Right? That's confusion, and it happens in your jury's eyes. Note those points, right? It happens on very simple subjects, and it happens on very simple topics that can be easily remedied, easily repaired, easily restored. But if you don't pay attention to it, you don't see it in your jury's eyes, you're not going to know to pick it up and repair it on redirect. And we're going to have one that has to do with that in our demonstration. If they're left with some sort of like open, vague, what happened there, you make sure you pick it up on it and remedy it. You said this on direct, you said this on cross. Explain that to the jury. One simple question I get at, fix that thing. Help the unanswered question that the jury now has in their mind. Think about what was unsaid. If they were confined to a yes answer, but it was yes, but I went to the gas station, yes, but I stopped at the store. Think about what's unsaid. Instead, you were asked on cross-examination about if you went straight home. Did you go anywhere else in between? I'm remedying, the explanation happens on redirect, and I'm remedying what they were confined to. And I like short, useful explanations, right? So it's still going to be, you have to think about it, it's still going to be open-ended questions. This is redirect. Just because my partner or my opposing counsel got to lead during the cross that just happened, I have to return to open-ended questions. So I want to lead them in, like who were the top 5? That's not a leading question, that's not calling for a yes or no. That's saying who were the top 5. And so you have to think about your questions that way. get them back to open-ended questions and have them give short, useful explanations. I prep my witness to give me one thought, this is on direct examination too, and if I want more questions on that area, I'll ask more questions. If I want more information, more questions. You never have to worry about how long your answer's going on, and I never have to worry about you blabbing and me getting you back to the point. It works for both of us. Give me one thought each time. Why not even be one sentence, one thought? Same thing here. Explain why this happened. Explain why you gave that question on cross-examination. You still hold true to that principle of that's going to be a short, one-thought explanation. And if that's all I need, my judgment as the presenting attorney in redirect, that's all I do, and I wrap it up. And this is the demonstration of that. Counsel asked you about this thing. Why was that? So you refer them back to specific points in the cross-examination wherever they are. It makes it look absolutely, obviously shorter and more efficient than what just went on across. Here's some of the pitfalls, and then I'll end with this. Right? Asking, may I redirect, and not having it be not addressing the fact that the court or that the jury thinks that this is going to go on forever. Actually embracing the fact, like you see a lot of attorneys go, oh, do I have redirect, Your Honor? Holy God, so much came up, yeah, I have a long redirect. That is not a good way to start off redirect because you just turned off your entire jury. And there's lots of them, lots of attorneys that think that they're helping everyone out. Oh no, there's so many unclear areas now, I'm going to have to redo this whole thing. It's going to be longer than my direct. That is not a good sign for your jury. They've seen this character in the play. They want this character exiting stage left. They don't want longer. They want more efficient questions, answers, listening, and reacting, and get this clown off the stage. That's what they want. They want next character in the play. Call the play over. Feed me lunch. They want what's next, not more of this stuff. So make sure, I say briefly, you can say I have a few questions. Never say in any examination that I only have one question, right? Because then what do you do as an attorney? You lie to them because you never ask them one question. You always get it. All right, make sure you don't launch into leading questions. There's nothing to stop or make it look bad. You get up and redirect and you start leading them. Well, wasn't it really that when you got there that this really happened? Right? It looks like you're getting defensive and it looks like you have to feed the answers. Those are not having the witness answer short, useful explanations of what's really going on. That's the attorney trying to play attorney games with the other one that asks confrontational, confining questions. Don't do that. Even if you're able to sort of get away with leading questions, I want the witness to be the one doing the talking. I want to make it look like what happened on cross-examination was unfair, confrontational, and confining. Now it's your turn to talk. I'm back up here. You know what I mean? I'm home now. We're all home. Let's go do that thing again, right? And I want to make sure that they can ask questions and open-ended questions. It's a funnel, not a ping pong match, so do not just re-ask questions. You'll actually hear, right? This is my favorite one. There's one thing that I forgot to ask you on direct examination, right? You do not get to do that. Matter of fact, if those words come out of your mouth, the other side should object and say, Your Honor, it's outside the scope of my cross-examination. Why? Because they said they didn't even ask it on direct. This thing is supposed to be a funnel, right? You do not get to re-ask that which you asked on direct, and you don't get to ask things that you forgot on direct. And if you did forget it, you better not be saying it out loud, right? So make sure that you are tying it together and that it comes within the scope. But if you ask something on direct examination, how did you feel the night of the robbery? I would have felt terrified. You don't get to stand up and redirect and say, I want to go back to return the jury to what we talked about earlier this morning. How did you feel on the night of the robbery? Right? You've asked and that question has been answered. Objection, asked and answered, sustained. You do not get to ask that question again just because it's direct and now redirect. It has to be within the scope of and in light of the questions asked during cross. Lastly, these two. Furthering the confusion. Redirect, you should not take some issue that came up and presented two sides of something and then further the confusion. That's how I would classify it. It's tough to give people advice of don't get more confusing, but that's what happens most often. That is a pitfall of redirect. If you're going to go on and it's more than a couple of questions, and it's more than a couple of points, you risk confusing them more. If it was a simple thing that you testified on direct, they testified on cross-examination, and you think you can fix it with a short explanation, and that you need that explanation for closing to fix it, then do it. If not, you have to walk away and you have to not go down the road of making it more confusing for your jurors. And the last one is explaining credibility challenges. We'll see that one in the demonstration that comes up. Sometimes, maybe even rarely, when a witness is attacked through one of these credibility venues, if they are attacked on cross-examination and their credibility is impugned, sometimes there's an explanation there. Sometimes it's something like, you were asked about the law school application. Tell us about that, right? So the challenge is going to be narrow under the rule and only what they're able to do. But it doesn't mean in redirect that you don't get to offer your witnesses explanation as to why it's so. So sometimes on credibility challenges, you might be able to actually explain it to the jury. Yeah, here's why I lied. Yeah, here's why I had that conviction. Yeah, here's why it might be perceived that I have that bias, but I don't. So you can explain those credibility challenges. All right, that's all for redirect, and we're going to go into a demonstration.